Hello, practical law students, and welcome to the first of two lessons this week dealing with juvenile justice. Now, everybody has to deal with these lessons, my hybrid and online students, okay? We are not going to be working through this in class. So everybody has to be doing this on Canvas. Also, be sure you take your own notes as you work through these two lessons. I will tell you exactly what I want you to copy down on each one of the slides. So be sure you get that information down. There will be a little worksheet assessment attached to this for the end of the week. So be sure you get that done. That is a graded assignment. Okay. So be sure you're taking lessons or taking notes as we work through these lessons, so that you can complete that worksheet at the end of the week. All right, so let's talk about juvenile justice here. Juveniles in trouble with the law are treated differently from adults. Okay, at one point in time, children were put into jail alongside adults. They could serve long prison terms, they could face corporal punishment, and they're even sentenced to death for crimes that seem relatively minor by today's standards. So there is a change in thought over time about how we deal with juvenile delinquents, okay, and juveniles in trouble. So the first thing we're going to do here is we're going to look at the history of the juvenile justice system. Okay. Now, again, I will tell you exactly what I want you to copy down. There was a thought in the mid 19th century that the family, particularly the failure of the family, was the cause of delinquent behavior. And that the solution to that was a separate juvenile court to assume the responsibility that had once been the parent's job. Okay, so that's the mindset behind the juvenile justice system, that the family was falling apart for various reasons, that because the family was falling apart, you had all these juveniles committing crimes, and that we needed to have a separate legal system, a separate court to deal with those crimes and to take the role of the parent. At the same time, it was decided that prison was probably not the best place for juveniles, that we needed to rehabilitate them and take a more moralistic approach to help them learn community values. So prison was not the final solution in this. All right. So between the breakdown of the family and between these new thoughts about how we deal with these crimes and with this bad behavior, that's going to lead to the formation of the juvenile justice system. Now, here's what I want you to copy down. I want you to get this point down. Number one, the first juvenile court was set up in Cook County, Illinois in 1899. Okay, that's when the first juvenile court was set up, 1899, in Cook County, Illinois. Unlike what we have been working through, okay, with the two sides of a trial and all the steps of the trial and stuff like that, the juvenile court was set up to be very informal. Okay, get that down. All right, it was set up to be very, very informal. Now, there's still some procedures, but it's not going to be as detailed as, say, what we work through when we do our mock trials. Okay, it was based, and I want you to get this down as well, it was based on the concept of parens patriae, okay, which is Latin for parent of the country. The court assumes the role of a parent and is permitted to do whatever it thinks is necessary to help the child and the child's behavior. Okay, so the court is taking the role of the parent, okay, and can decide what it thinks is necessary to deal with the bad behavior. Okay, so be sure you get those last 3 points down: where and when first juvenile court was, designed to be informal, and this idea of parens patriae. Okay. Now, on the next slide, you do have to get everything on the next slide down. There are three groups of juvenile defenders. One is delinquent offenders. Okay, those are youths that have committed acts that would be crimes if committed by adults under federal, state, or local law. Okay, youths that have committed acts that would be considered crime under law. That's a delinquent offender. A status offender is a youth that has committed acts that could be a crime if committed by an adult. running away from home, skipping school, violating curfew, refusing to obey parents, engaging in certain behaviors like underage consumption of alcohol. Status offenders, youths who have committed acts that would not be crimes if committed by an adult, okay? Running away from home, skipping school, violating curfew, refusing to obey parents, engaging in certain behaviors like underage consumption of alcohol. These are bad things, but they would not be considered crimes if committed by an adult, okay? Then you have a completely different selection, the neglected and abused children, okay? That's when we need the court's protection from a parent or guardian, okay? If it's neglect, the parent or guardian is charged with failure to provide adequate food, clothing, shelter, education, or medical abuse or medical care. If it's abuse, the child is sexually, physically, or emotionally abused. Okay. So this last group, they need protection from the court because of something the parent or guardian is doing, not because of something they have done, but because of something the parent or guardian has done. Okay. So delinquent offenders, juveniles that have committed what would be considered crimes, status offenders, they've committed an act that would not be considered a crime, and then neglected or abused children, they need protection, they need help from the court because of something the parent or guardian is doing to them. Okay, so those are the three groups of juveniles. Please be sure you get those three definitions down. Now, in most cases, in most states, the juvenile jurisdiction extends through age 17. Okay. Now, here's the point I want you to get down on this slide. And this is the only thing you need to get down on this slide. Once a juvenile reaches the age of majority, 18, usually it's 18, a young person can be prosecuted in adult court. Okay. So, usually when you turn 18, that's when you move up to the adult courts. Okay. Up to age 17, you're considered a juvenile, and juvenile courts might be an option. But when you turn 18, that's when you move up to the adult court. Now, that being said, all states have processes in place that allow some juveniles to be tried in adult court under exceptional circumstances. All right. And we talked about this before. For a crime to happen, you have to have the illegal act and you have to have the motive, the intent. Okay. If it can be successfully proven that a child did the crime, they knew what they were doing, they had the motive, they had the intent, then it is possible they could be sent to adult court. Okay. Especially if age 16, 17, age 15, 16, 17. Okay. And then definitely age 18, that's when you move up to adult court. The juvenile justice system continues to evolve, partly because of society's tension between rehabilitation, which is a humanitarian philosophy, and the need to punish juvenile offenders, this control philosophy. Okay, there's a big conflict. We want to rehabilitate, we want to treat children fairly, but at the same time, if they know what they're doing, they need to have consequences. Okay, they need to be punished. So that's why the system continues to evolve and change between these conflicting needs for rehabilitation and punishment. Okay. And while there are some standards in each state, it does vary from state to state. Okay. It does vary significantly state by state. All right. Now let's get into one of these categories. Okay, we talked about delinquent offenders, we talked about status offenders, we talked about neglected and abused children. Let's talk about status offenses first. Okay, let's talk about status offenses first. All right, so number one, and again, I apologize earlier, and I want you to copy this down. You are a status offender if you commit an act that would not be considered a crime if committed by an adult. Okay, so you're a status offender if you commit an act that would not be considered a crime if committed by an adult. Okay, get that first point down. If you are a status offender, you can face charges such as being beyond control, habitually disobedient, or truant from school. Okay, these are some of the charges that can be leveled against you if you are a status offender. You may simply be emotionally troubled and need medical help, emotional help, or both. So part of the reason this falls under that rehabilitation umbrella. Part of the reason we have offenders is because the reason they're committing the acts, okay, which is simply bad behavior, is because they may need help. And instead of charging them with a criminal act or charging them as an adult, if we keep them as a juvenile and we charge them as a status offender, we can get them that help. And that help doesn't necessarily mean prison, okay? We don't have to send them to prison. Many status offenders are runaways, okay, or young people with alcohol or drug problems, which is affecting their mental capabilities. They need help to break those cycles, okay? If you know somebody who falls into this category, okay, and the material that we use is big about getting people help. You can call 1-800-RUNAWAY or go to www.1800runaway.org and get people help if they need it, because that's what status offenders are in need of, is help. Okay. Now, status offenders make up about 20% of all juvenile arrests. Okay. So 20% of those coming through juvenile court fall under this category of status offender. Here's the other thing that I want you to get down. So I want you to get down the first part of the slide. I want you to get down this part too, okay? Status offenders must be represented in court hearings, okay? Now, how that representation takes place, the nature and quality of that representation is going to vary state by state, but status offenders must be represented in all court hearings, okay? So even though this is technically not an adult prosecution, okay, this is not a trial or anything like that, they must be represented in all court hearings. Now, when it comes to status offenses, a single violation is not enough to support supervision. This has to be a habitual, repeated offense. One single act is not enough to support supervision. This is what I want you to get down on this slide. Most states require proof that the young person is habitually disobedient or has repeatedly run away, skipped school, or been out of control. So again, one incident is not enough. There has to be a history. There has to be a series of proof before the courts will take action. Okay, most states require proof that the young person is habitually disobedient or has repeatedly run away, skipped school, or been out of control. Okay, that's the only thing you need to get down on this slide. The struggle is how to determine how best to treat these youth, okay? When does it cross over to criminal activity, and when is it just bad behavior, okay? That's the struggle. How do we treat it? When do we cross? When do the offenders cross the line into criminal behavior? Sometimes parents will ask the court to file a PINS petition or a CHINS petition, okay? PIN stands for person in need of supervision. CHINS is child something in need of supervision, okay? So parents sometimes ask the court to get involved through a PINS petition or a CHINS petition, okay? We use the term CHINS a lot in school, all right? Now, again, status offender, you're doing things that are wrong but would not be considered crimes committed by an adult, but you have to be represented in hearings, in all hearings, and one act is not enough to require supervision. This has to be something that is repeated and habitual. Okay. Now we're going to move into talking about the juvenile justice system today. And again, I will tell you exactly what I want you to copy down. All right. In the 1960s, people argued that the juvenile court system was providing harsher treatment than the adult system without the procedural safeguards and constitutional rights that defendants would have in adult court, okay? That the juvenile system, in order to curb the bad behavior and kind of make an example of those that are violating certain acts, that we were being tougher on them, and they didn't get the protection that they would normally get because of the Constitution, even though, to be honest with you, constitutional rights apply to all people, okay? 1960s people were saying, If you went to juvenile court, you were not getting the same protection. Okay. What I want you to get down, I want you to get down the rest of this slide, because we're going to talk about the Galt case. Thanks to the Galt case, juveniles now possess many of the same rights as an adult. Okay. We already talked about with status offenders, you have to be represented in hearings. Now, that representation is going to vary state by state, but you have to be represented. Well, that is a protection under the Constitution. Thanks to the Galt case, juvenile offenders have the right to be notified of the charges against them. They have the right to an attorney. They have the right to confront and cross-examine witnesses. And they have the right to remain silent. Okay, so thanks to the Galt case, juvenile offenders now are guaranteed these same rights: the right to be notified of the charge against them, the right to an attorney, to confront, cross-examine witnesses, and to remain silent in the juvenile justice system. Okay, I'm going to argue those rights were always there, but now it's become official. Now it's in writing. They definitely have them. Okay. The Supreme Court has said, okay, so be sure you get down all the things in the Galt case. The Supreme Court has said that not all procedures used in adult criminal court apply to juvenile court proceedings. Okay, there is a difference between these two systems. Okay. On this slide, I want you to get down the Juvenile Justice and Delinquency Prevention Act of 1974. This was formed by the Department of Justice's Office of Juvenile Justice and Delinquency Prevention. Okay, from this understanding that the juvenile court system and the adult court system are different, we get this act. Okay, now here are some of the differences. Those status offenders, number one, they are to be removed from institutions, namely jails. Okay, status offenders are not to be put in jail. Number two, if a juvenile is in a jail, juvenile offenders are to be separated from incarcerated adults. Okay, so number one, status offenders be taken out of prison. Number two, if it is a juvenile offender and they're still in prison, they are to be separated from adults. Okay. And number three, the state takes responsibility for developing community alternatives to incarceration and for improving the juvenile justice system. Okay. We talk about balance of power a lot with government. All right. It's up to the states to deal with developing community alternatives to incarceration and improving juvenile justice systems. Okay. So the national government's going to be involved in a little bit, but then the states are going to take over as well. You don't have to copy this last part down, but in the 1980s and 1990s, being too soft on crime, many states changed their laws so that at least some offenders could be prosecuted in adult criminal court and therefore receive more severe punishments. This is the most controversial issue in the juvenile justice system today. We talked about it on one of the other slides, this tension that exists between the desire to rehabilitate and take care of juveniles and to punish them when they do something wrong. And we keep seeing the pendulum swing back and forth. At one time in the 1960s, we were too harsh. Then in the 1980s and 1990s, we become too soft. Okay? This is the greatest controversial issue and the greatest source of tension when we're dealing with the juvenile justice system. Okay? This desire to rehabilitate, but at the same time, this desire to punish as well. Now, the last thing we're going to talk about here is we're going to talk about prosecuting juveniles in adult court, okay? And then we're going to talk about, in our second lesson for the week, we're going to talk about the procedures in juvenile court, okay? So we're talking about prosecuting juveniles in adult court. The only thing you need to copy down on this slide is this first part right here, a juvenile waiver. A juvenile waiver allows juvenile court judges to waive juveniles to adult court after a hearing for prosecution. So you still have to go to juvenile court. But if the judge determines that you knew the act was wrong and you had the motive and stuff like that, this is not some sort of habitual offense like a status offense or something like that. It's a real crime and it would be prosecuted as a crime if you were an adult. You can be waived to adult court thanks to the juvenile waiver. Okay? Be sure you get that down. There are things called statutory exclusions. Okay, that's a state law that requires certain offenses committed by juveniles be prosecuted in adult court. It's an automatic transfer. Okay, so there are statutory exclusions. You also have direct files, which give prosecutors discretion to file charges against juveniles in adult court. Okay, again, both of these are dealing with the concept for a crime to have happened, you have to have the illegal act and you have to have the motive, you have to have the intent. If it can be proven, especially if you're 15 or 16 or 17, if it can be proven that you have both of those, that you have in fact committed a crime, and the crime is so grave that it would be considered a crime by an adult, you can be sent to adult court, even if you're a juvenile. Okay? Now, studies have shown that youth transferred to adult court often reoffend at higher rates, okay, than those treated in juvenile courts. Again, this is part of the tension. Okay, do we keep them in juvenile court and maybe not risk them committing other crimes in the future? Because studies show that if you get sent to adult court, you will commit other crimes in the future. And the majority of juveniles are still treated in the juvenile justice system. It is a very, very rare case that you would be automatically sent to an adult court. Okay, most juveniles are still handled by the juvenile justice system, although these things like juvenile waivers, statutory exclusions, direct files still exist to bump you up to adult court. New research in brain development shows that young people's brains continue to develop into their 20s. So there's arguments that we should not use the age of 18, okay? That in some cases, not until your 20s have your brain fully developed, and maybe we need to extend this idea of juvenile justice to people in their 21, okay, until they're 20 or 21, all right, because of this research in brain development. Especially the portion that affects impulse control, the capacity for independent thought, and the ability to resist peer pressure. That is not fully developed until you're in your 20s. Okay, so there are some arguments that are being made that the juvenile justice system needs to cover you until you're in your 20s. Policymakers should focus on sentencing laws that address punishment and treatment within the juvenile system rather than dealing with these juveniles in the adult system. Namely, maybe we need to focus on the punishment aspect of it, okay, and not whether or not we're going to try them in adult court or not, okay? Maybe broaden the punishment under juvenile systems differently, have different definitions, different criteria and stuff like that. Focus on that aspect, not whether or not we're going to try them as adults, okay? Focus on the punishment, not the actual trial itself, all right? Now, that's going to be it for lesson number 1, just kind of giving you some background to the juvenile justice system. Where we're headed with lesson number 2 are the procedures in juvenile court themselves. Okay, so be sure you pay attention to that and take some notes on that lesson as well.